Gerald, very good evening to all of you. The Nagpur branch has organized VCM series on insolvency and bankruptcy code for the benefits of the members. We have already taken one particular session where C. Amit Poddar has spoken about corporate insolvency resolution process. In today's session, we have scheduled VCM on pre-package insolvency process. Pre-package insolvency process is a kind of bankruptcy process where a restructure plan is agreed in advance of the company. In my opinion, this particular process will definitely have a time-bound insolvency resolution. And today we have our own CA Neeraja Kartik with us to deliberate upon the particular topic. My request, our chairman CA Jiten Sanglani sir, to give his welcome address.
Thank you so much, Treasurer C. Dinesh Patil. I hope I'm audible and there is no echo.
Yeah. Yes. Sir.
So, yeah. Thank you so much, Dinesh. Friends, today we have with us a very excellent speaker in the form of CA Neeraja Kartik ma'am. And we are privileged to have you here, ma'am. A warm welcome from Nagpur branch to you.
Thank you. Thank you.
Yeah, as rightly stated by Dinesh ji, that this particular pre-package insolvency topic, which we are actually having with Goa branch, and this is actually organized by Committee of Insolvency and Bankruptcy Code, headed by CA Durgesh Kabra ji, and Vice Chairperson of the committee, CA Sri Priya ma'am. So thanks to both of them for allotting us this particular VCM series, and thanks to Goa branch for coming together and having this program. Friends, there is a lot of disturbance at the branch site today because we have some construction work going on. So kindly bear with us if there is some say background noise. As rightly stated by Dinesh, that this particular topic is one of its kind, which is actually a resolution process altogether. And I personally feel that such kind of topics which are new to the profession should be taken care of. And we have excellent speaker in the form of Neeraja ji. And I think she'll be covering this particular topic, the whereabouts, basically what it is, how we can actually take it forward, and what are the pros and cons. So she'll be covering everything. And I think we should look forward to learn a lot from this particular session. We have two more sessions in insolvency, say VCM series, which is happening on, say next session will be happening on 11th of June. CA Prasad Dhara will be taking that session. And it is basically on stressed assets. And the last session is on 18th of June being taken care of by CA Atul Rajwarkarji. So I request you all to take benefit of this series. Do register for the next two sessions as well. And there are a lot many programs that are planned next week as well. So 9th, we have a program on financial and tax literacy drive. The circular will be coming to you very soon. 10th, we have international taxation series, which is starting on 10th, and 11th, we have the second session of international taxation series. And again, as I said, 11th, we have the insolvency VCM session as well. So looking forward to all of you to say connect to the Nagpur branch in the initiatives and have a good learning. With this, I wish to conclude. And once again, thanks each one of you, along with the committee members who have connected for this particular VCM. Thank you and thank you all.
Thank you, Chairman, sir. Now I request MCM Trupti Bhattar to kindly introduce C. Neeraja Kartik to all of us. Thank you, Trupti.
A wonderful evening to one and all present over here. It's my privilege to introduce CA Neeraja Kartik ma'am. She is a chartered accountant, holding bachelor's degree in commerce and a registered insolvency professional, having post-qualification experience as a CA for more than 19 years. She has been in employment with biggest audit and accounting firms in India, like PwC and eServe International, which is a member of Citigroup, for the first 4 years of her career and have been in practice ever since. During the 13 years of practice as a chartered accountant, she was a partner at K.S. Muralidharan and Company, which is a 35-year-old firm from Chennai, handling audits and consulting assignment for some major PSU bank and companies. She has been a renowned faculty at Accounting Academy for Economics and Commercial and Corporate Laws Currently, she is a director at Nakshatra Insolvency Resolution Professionals Limited, a registered IP from Nagpur, having offices in Mumbai, Ahmedabad, Pune, Delhi, Nagpur, and handling various resolution and liquidation cases for the firm. We are grateful to you, ma'am, for accepting our invitation, and I welcome you here on behalf of Nagpur branch. Thank you so much, ma'am.
Thank you, Tripti. Neeraja ma'am, now stage is all yours.
Thank you very much. Thank you, Trupti. That was a very, I'm honored with all your words. Sir, I'll request you to put your this thing on mute because there's a lot of background noise. And I want to say one thing. Before we start with the session, since this is a second session, I'm sure many of you would have attended the previous one, CIRP by Amit Poddar. That would help me to understand where to draw the line when it comes to going into too much detail. If that's something that it's been already covered, then I'll take it, little superficially. So I would want an interactive audience here. I'm a lady. I can talk for hours without any audience also. But then I would want some interactive session here. So can I, if you put your video on, if you can respond a bit, it'll be good. I can go on otherwise anyways. So the first thing I want to say, prepackaged insolvency resolution process. It's a very recent amendment which has been introduced last year, 4th of April 2021. The amendments came into force. So before that, IBC had only either CIRP or liquidation. But after 4th of April 2021, prepackaged insolvency has also been introduced. So it's a spin-off from CIRP process. Initially, as we understand the IBC code, the purpose of IBC was not just settlements. The purpose of IBC was to maximize the value of the enterprise, of any business which went into, defaulted on low account payments to suppliers or to financial creditors. The purpose was not to sell off the assets and to close the account. The whole purpose of IBC, why it was brought in, was to ensure that the enterprise fetches maximum value, not just for the financial creditors, but for employees, for operational creditors, all the stakeholders, let's say. So the purpose of prepackaged insolvency is very, very similar. So here the purpose is not just to close loans or to pay off debts. The purpose is to ensure that the enterprise runs as a going concern. The value of the enterprise is retained, or in fact, if managed properly, it could be enhanced as well. So the basic crux remains the same in prepackaged insolvency and CIRP, corporate insolvency resolution process as well. So I will screen share the PPT. One thing I want to tell you is that after the end of the session, I will share FAQs that I have made on prepackaged insolvency, wherein I have really made, where I've tried to simplify the prepackaged insolvency resolution process for you. So the FAQs come in very basic one-line questions and max 2-3 sentences answers. So that would help you further, which I'll be sharing at the end of the session with all the members. So I'll put it on the group chat itself. So can I go and start with the PPT presentation? Yes?
Yeah, definitely.
Okay, sir. Thank you. Thank you for the feedback. It always helps. Right. So prepackaged insolvency resolution process was brought in on 4th of April 2021. Who is it applicable to? The first thing I want to ensure that you understand basic terminology here. We will be using a lot of shortcuts and abbreviations for a lot of this thing. I will explain as and when we use the words anyways, but in the meantime, I would like to introduce you to those terms. Whenever I say it's RP, it's for resolution professional. FC for financial creditors, or to um, explain it, it's basically lenders, financial institutions who have lent money against time value of money, that is for interest. Those who have lent come under the definition of financial creditor, both against security or without security. The financial creditor can be a secured financial creditor or a unsecured financial creditor. OC is suppliers of goods and services, operational creditors. CD is the term we use for the company or LLP which goes into insolvency or which has applied for prepackaged insolvency resolution. They're known as corporate debtor. We can use the word company, or we use the word company or corporate debtor interchangeably. But corporate debtor means the company which is in question in insolvency. Whenever we say board, that's the Insolvency and Bankruptcy Board of India, which is the regulator here. And the code means the IBC 2016. So here we have, again, the terminology which I'll be using throughout the session, and I'll be explaining as and when we use them as well. So MSME is very, very important here because prepackaged insolvency is applicable only to micro, small, and medium scale enterprises as defined in Section 7 in MSME Acts, right? So why CIRP, why pre-packed and why not CIRP? I'll stop screen sharing a bit here because I'll explain what the difference is here, and then I'll move forward. Those who attended the CIRP session, they know that the corporate insolvency resolution process starts with admission of application. Either three people can make the application: financial creditor, operational creditor, or the corporate debtor themselves under Section 10. If there is a default of at least minimum of 1 crore rupees, corporate insolvency resolution process, the application can be made by financial creditor, operational creditor, or by the corporate debtor himself, saying there is a default. See, one thing I would want to explain here is how IBC is different. Is here we're not talking about capability of the corporate debtor, whether they have the ability or not. What we are talking about is there a default or not? There IBC is very clear. Even if you're very capable, but if you have defaulted, it doesn't mean that your assets have to be less than your debts always. If you have defaulted, if there is a default, a case can be filed by you against you. And once it is admitted by the Honorable NCLT, adjudicating authority that we call, the CIRP starts. The period for CIRP is usually 180 days, and one-time extension of 90 days can be obtained. So, 270 days period is for CIRP. Now, the minimum default value there is 1 crore rupee, and the case can be filed, the application for insolvency can be filed by financial creditor or operational creditor. The difference in prepackaged is here always the application is filed for insolvency by the corporate debtor themselves. And the default amount here is not 1 crore rupees, it is 10 lakh rupees. If there is a minimum amount of default of 10 lakh rupees, the corporate debtor themselves go to the bankers and say, okay, we need a restructuring. We are not able to continue the business the way it is functioning, the way our debts have mounted, and we are unable to service the debt. So we need a restructuring. But just with one financial creditor having the restructuring or said OTS will not help. We need an entire restructuring package. So they approach the financial creditor with the idea, and the minimum default value here is 10 lakh rupees. So we've noted the difference. The first basic criteria is between the amounts itself. And the second point is here in pre-package, the application can be only filed by the corporate debtor, which is an MSME. I'll get into that part later, which MSME can apply and everything. So basically CIRP, CIRP, the period is 270 days, and here the period has been shortened the entire resolution process here takes much shorter period of time, which is 120 days. Why? Because this they have divided the CIRP. It's very similar to CIRP. That's the reason I'll keep drawing parallels between these two. But the first thing here is, in common man parlance, if I have to say, it's a mix of CIRP and OTS. Here, there is an informal procedure which takes care, which is taken before the banks, taken up with the banks, where you enter into an agreement informally with the financial creditors, bankers or financial institution, or even unsecured financial creditors. There's an informal negotiation, there's an informal settlement, and then a formal process starts where you make an application with this settlement that you've arrived with the bankers to the NCLT. So it's a mix between formal and informal procedure where, so basically you can, that amount can take a longer period of time. The negotiations with the financial creditor can take 3 months, 4 months to arrive at. Once that happens, the period is much lesser here. Prepackaged insolvency period is only 120 days. So that's a basic difference between CIRP and prepackaged insolvency. And of course, the major difference here is prepackaged insolvency is only applicable to micros, small and medium scale enterprises, whereas CIRP can be initiated against large corporates, etc. You've seen most major large corporations are under IBC, including Jet Airways, Reliance. All these are under, they're large corporates in IBC, in insolvency. So the major difference here is it's only applicable to MSMEs. So the purpose is to promote settlements in MSMEs and to bring them back into action, to help them revive any business organization. That's the whole purpose of this act. So can I move forward? A bit of this thing will be helpful. Feedback? Okay. So now one more difference in CIRP is the moment an application is admitted, the CIRP starts, the entire management of affairs of the organization vests with the resolution professional. The management, the board of directors have no legal authority. It's a suspended, the board is suspended, and all the powers of the board vest with the resolution professional. So basically, if it's a going concern, the resolution professional is responsible for managing the day-to-day activities. And even if the concern is not a going concern, the resolution professional is responsible for ensuring the safety of the assets, for entire management till the time that there is a resolution, or if it goes into liquidation, the entire day-to-day operations are now taken care of by the resolution professionals. Now, sometimes it may happen the resolution professional may be very they may be very good at certain may have certain experience in certain industry, but may not have a very hands-on experience in some other industry. So there's a possibility that the operations are hampered, the value might, there could be job losses of employees or workers, or there could be operational issues which may crop up, and our resolution professional may have to hire external agencies to help them with that. All that process is a bit cumbersome. At the same time, there's a risk of erosion of wealth of the enterprise, since the promoters are not actively given any, they are supposed to support the resolution professional, but they are not in a position to make any decisions for the organization. Whereas in prepackaged insolvency, prima facie, the operations of the organization still are with the management, with the promoters or the management of the company, who know the operations of the company in and out of the corporate debtors. They understand the corporate debtors activities way better. So there is a possibility that the value doesn't go down, there's not erosion of wealth There's a possibility. And also, some people might differ with me here. They say, no, the management is the reason why it has come to this position. How can they be trusted with the organization again? I feel you here, and let me clarify here. Any point of time during the prepackaged insolvency resolution process, if the financial creditors feel that the operations are getting hampered because management is taking undue advantage there, they can make the resolution professional responsible. They can take away the rights, and just like CIRP, they can again give the reins of the organization in the hands of resolution professional. So both the options are there here, which is not with the case with CIRP. So the pros here are, a lot of times there's a lot of hostility from the management to the resolution professional. They don't share information properly because shift of power and loss of, they always worried that, any information they share can be used against them, or they may land. The fear is always there, which is not there. Moreover, since there is a lesser interference by the courts here, the time taken for the resolution process is much lesser. So these are various advantages, and ultimately, once the prepackaged insolvency resolution process is approved, the resolution plan is approved by the adjudicating authority, the NCLT, it makes it binding on all the stakeholders. So it kind of is assertive and conclusive in nature. So those are advantages that prepackaged insolvency resolution has over corporate insolvency resolution process. It has taken the best of both worlds, let's say. So that way, it's little advantages and it's speedier in nature. At the same time, the cons, obviously, the fact that it is still with the management, they can always take advantage of it, and that may not result in the same outcome as desired. So that also may happen. So again, I'll stop sharing the screen a bit and like to interact. Are we going okay? Is the speed okay? See, my purpose here is not just for me to talk or you to listen, but I would want you to take something out of this session. So is the speed okay? Thank you, Rishi. Fine. So I'll take Rishi's word and on it, and I'll move forward. So basically, now we have understood it's like an OTS, and why I feel every chartered accountant should know about insolvency professional or not. We all have clients who are going through certain financial difficulties, and when we know the process of prepackaged insolvency better, we are able to guide them better as to OTS is not the only solution, or insolvency is not the only solution. There is a midway, which is the best of both worlds, where it takes advantage of OTS, where there is a settlement which has happened, which has already happened. You know exactly what amount, not exactly, but then you know the amounts around which the settlement can happen. Banks know that definitely there is going to be a settlement. In CIRP, the resolution process starts, and then bids either they advertise. Sometimes there are bids there, or there sometimes nobody comes forward to take over the company, and it goes into liquidation. In fact, 85% of the companies are going into liquidation. So in prepackaged insolvency resolution, at least there is a surety that there is a resolution. End of the day, it may not end up into liquidation. The other very big difference between CIRP and prepackaged is CIRP is a very one-way traffic. Once a company enters into CIRP, of course, withdrawal may happen, but if it doesn't get withdrawn and if there is no resolution, it always goes into liquidation, right? In prepackaged insolvency, if the process is started, and if there is ultimately even the base resolution plan which started, it doesn't get approved, it can go back into normalcy. It doesn't go into liquidation. It may go into CIRP eventually, but the process is terminated. Doesn't mean the company goes into insolvency. That's a huge difference between the two. Once a company enters into CIRP and there is no withdrawal of application, it's only one-way traffic. There's no going back from there. It will always go into liquidation. That's not the case with prepackaged insolvency resolution, right? So that's one very, very big difference. I don't know if I'm using too many jargons or too much of technical terms here. I know I was like Tripti said, I was into teaching, so I always go into too much detail, and I have a habit of asking for feedback. If you understand, I'll go further. So I'll any queries for me? Anything that you would want to ask me? I'll wait for your queries, sir. Or should we take up the query session at the end? I should carry on with my session and take it up at the end. That also is a option. Okay. So since I'm not seeing any queries either in the chat session, chat box or here, I'll move forward and I'll take up the process. So now we know what is a prepackaged insolvency. It's basically a corporate debtor approaching a financial creditor, all the financial creditors saying, I'm in no position to pay the debt in full. I need restructuring of my loan. I need a bit of time. I need reduction in the debt. And otherwise, my debt has mounted too much and I'm not able to carry forward like that. With that proposal, an MSME, an eligible MSME, let me put it this way, because being an MSME is not enough. An MSME which is eligible how? Under section 29A of IBC, which is not who are not disqualified under section 29A are eligible MSME. So both the points are important. An MSME which is eligible under section 29A of IBC approaches the bank or the financial institution or unsecured financial creditors saying, I need to restructure my debts. Once that they agree upon it, at least 66%, I will come to it later. Once they agree upon it, with that, they make an application to the NCLT saying, the bankers have agreed for this plan and we want to go for prepackaged insolvency resolution. So that's the first step. So moving on, I heard some voice there. Is there a question for me? No. Okay, fine. So we'll move forward. So what is the process? What is the distinct eligibility for prepackaged insolvency resolution? Like I already said, eligible MSME, which is as defined in section 7 of Micro, Small and Medium Scale Enterprise Development Act 2006 is eligible. The minimum default value here is 10 lakh rupees. Secondly, the most important aspect, under section 29A of the code, as I explained, the code means the IBC, Insolvency and Bankruptcy Code 2016. Those who are eligible to submit a resolution plan only can file an application under this section. Third thing, the third very important part is that this company or the LLP shouldn't have undergone a prepackaged insolvency in previous 3 years. So it can happen only once in 3 years. Every 6 months, you cannot keep filing. Or there has not been any insolvency, under corporate insolvency in last 3 years. No CIRP should have got completed here. Or it's not undergoing. While making the application, there should not be any corporate insolvency resolution process going for this corporate debtor, or it's not under liquidation. These are the few things. No CIRP should have got concluded in last 3 years, or prepackaged insolvency should have got concluded in last 3 years, or there is no insolvency resolution going on. The company is not undergoing any CIRP process, or there's no liquidation order, only then you can file. This is the basic eligibility for filing. So every time there's a client, you have to basically verify these things, and only then we can go forward. The second and very, very important question, and there are a lot of, in fact, contradictory case laws also, evidence of MSME. How do you know whether, how to define an MSME? Like I said, definition is there in Section 7 of MSME Act. And how to prove, what is the evidence that this corporate debtor is an MSME? So of course, there's Udyam certificate. If you have an Udyam certificate, fine, but that is not mandatory. As you can see, law says, or the equipment or turnover should be as per the MSME, this thing that's certified by a chartered accountant. So Udyam certificate, but at the same time, courts insist on Udyam certificate. There have been cases where Udyam certificate has been made mandatory. So I suggest that every time any client comes to you who is an MSME, always encourage them to have an Udyam certificate, especially in CIRP. It's very, very important. I'm sure in other laws as well. Okay. Who can apply? Only corporate applicant, the company or an LLP. Okay. See, the forms I have compiled a list of forms, and again, I'll be sharing them. At this point, we can't really look at the forms. We'll understand the process in this session. And end of the session, I'll be sharing an FAQs with you. Of course, this PPT shall be shared with you. And along with that, all the forms which are required, detail of a screenshot of that also can be shared with you. Okay. Now, like when I explained the basics, you would have understood by now, or for people who have joined late. Prepackaged insolvency can be divided into two major phases, but let's say three phases. So first is pre-initiation phase, before filing of an application at all. This phase, you've not even filed an application for prepackaged insolvency resolution process. What happens before that? Before that, only major action happens. Majority of the process is completed. That's the reason, unlike CIRP, here the time taken or time provided also is very, very less. The first is the corporate debtor. The first step here is the corporate debtor will have to convene meeting of financial creditors. Financial creditors, as I defined in the initial FCs of financial creditor, can be secured financial creditors or unsecured financial creditors. A lot of times because of surface especially, we believe that when we say financial creditor, it has to be a bank. No, even an unsecured financial creditor where there's no security or there's a mortgage, they also are considered as financial creditors. So any financial creditor, basically you convene meetings with them, and the financial creditors have to be unrelated parties. Just like CIRP, no voting right is given to related parties here. Related financial creditors have no say in the process. The meeting has to be convened of whose? Of unrelated financial creditors. This is a very, very important aspect. Any person who has the understanding of the process, a lot of my esteemed colleagues here for the clients, or there could be some IPs here. Pardon me if I'm taking very basics and emphasizing too much on them. It's for those who are totally unaware of the process. They might find it helpful. So all those who are experts here, they have to pardon me every time I explain very small bit terms here. So you have to make the corporate debtor has to convene a meeting and give at least 5 days notice, unless a shorter period is agreed by all of them. So at least 5 days notice with venue, date, agenda, time, everything has to be provided in the notice itself, so that they come prepared with what they can expect out of the meeting. The third step is the applicant or the corporate debtor, from their books of accounts, from their books of account, they'll make a list of creditors and what is the amount due. See, the books, we are all CAs here or financial experts here. We know that the amounts may vary in various books. Here, the applicant is talking about as per their books of accounts or as per the documents with the bank or financial institution, what is the amount pending, and as per their this thing, what are the calculations. So this uh, base, from their books, what is the total list of creditors, financial creditor, operational creditor, as per their books, what is the this thing they have to submit at the meeting. Now, one more very important aspect here is it is mandatory, it is compulsory to have a resolution professional assigned. So before you make an application, right now we are at the pre-application stage. So at those financial creditors having at least 10% of value of the debt shall propose name of eligible insolvency professional under the regulation. So who can propose? Those who have at least 10% of the debt in the entire scheme of things, they can propose the name of prospective insolvency the resolution professional. IP's name has to be given. That's the next step. The first thing is to convene a meeting of unrelated financial creditors. Secondly, to give them a list of all the creditors. Thirdly, a resolution professional's name has to be suggested by creditors holding at least 10% of value of debts. Now, so who appoints the resolution professional here? UFCs representing not less than 66% value of debts. UFCs, unrelated financial creditors. They have to approve who the resolution professional for the process will be. Moving on. This is a very, very important aspect, and you have to make those who are taking notes should take note of this aspect. Even if the financial creditors, unrelated financial creditors, approve with 66% majority of the base resolution plan, and they approve of the pre-packaged resolution process, from then the application for pre-packaged insolvency resolution process to start has to be filed within 90 days. It's not like you can take the settlement has happened, now you will go hunting for lenders and in good 2 years you'll file. No. Once it is approved within 90 days, means you cannot first decide the amount and look for sources of funds. That is something that you have to know, that you have to be prepared with the sources of funds, because once you make the application, once it is approved within 90 days, you have the corporate data, the management, the directors or the partners of LLP have to make an application. So when they go to convene the meeting, they have to make a declaration that if the process is approved of within 90 days, the application shall be filed with the adjudicating authority. Second declaration that they have to file is the purpose of this resolution process is not name of the resolution process professional has to be approved and submitted. Now, another very important aspect is the management cannot wholly take the decision here. There has to be a special resolution passed by the shareholders approving the prepackaged insolvency resolution. So once it is passed by the shareholders, the management can take it forward to the financial creditors. Unrelated financial creditors who sits with the resolution professional can be appointed by the unrelated financial creditor who have 66% of voting rights minimum. Okay. Now, here we have to understand that when we approach the bankers, we have to go the corporate data. When I say we here, the corporate data, since they are the persons applying, the corporate data has to go with a BRP. That's the terminology I'll be using a lot. But as I have explained in the screen itself, it's called the base resolution plan. A basic resolution plan has to be given, saying, okay, and here all secured creditors, unsecured creditors, how you're going to operational creditor, how much you're going to be paying them, what will be the methodology, how much CIRP cost is anticipated, how much resolution professional fees will be, or cost of resolution. The entire plan has to be provided to the financial creditors, to the at the meeting itself. So this is something which is a very important aspect again, along with the declaration that it is not to defraud the creditors, along with the approval of with the special resolution by the shareholders. A base resolution plan has to be submitted. Now, can I go forward? Okay. Now, along with that, of course, there are other documents which have to be submitted. An affidavit has to be submitted that the corporate debtor is eligible under section 29A of the code to submit a resolution plan, that they're eligible applicants. That is something that I explained a few minutes back. Secondly, a statement of affairs. If you're making the application today, not later than before 14 days of the application, a statement of affairs of the company, the financial position of the company has to be provided. Then names and addresses of the members, partners of the, and then how much is the shareholding, all these details have to be given. Then application fees proof that they have filed for application with, and the fact that fees has been paid, all these things have to be provided. And a copy of application, if approved, has to be first filed with the IBBI, and only then you can file it with the adjudicating authority. So these are minor details which have to be kept in mind. So like I said, the first application copy has to be served with the Insolvency and Bankruptcy Board of India. Only then it can be filed with the adjudicating authority. Now the timelines given here, once the application is filed after approval by 66% of unrelated financial creditors, the application can be filed with the Honorable NCLT in the state where the registered office is there of the corporate debtor. In the same NCLT jurisdiction depends on where the registered office of the company is. And within 14 days, the Honorable NCLT has to admit the application. And the date of admission, the pre-package insolvency process starts. So I'll again take a break here. Is there anything that you would want to ask? Or if you're making a note, we can, of course, there will be a query session at the end of the session. But if you have any queries before I move forward, I'll be happy to answer them. Okay. So I see no queries here. So I'll again share the screen and I'll move forward from here. Okay. Okay. The process starts with the admission. Now again. Okay. On the date of admission, the commencement of CIRP happens on the date of admission of the application. And just like section 14, if you have attended the CIRP, there is a moratorium. A moratorium is declared. Moratorium simply, in if I have to explain in common terminology, no procedure against the no suit or no arbitration proceedings or no can be filed against the company during this period. So during the moratorium, no, even if there is a charge with the GST department or income tax department, they cannot sell the assets because it is under moratorium. No new suit can be commenced against the company, or no existing suit also cannot continue during this period. All the legal proceedings, including arbitration, come for a halt. That is the purpose, so that no new interest is created, and that can complicate. And moreover, one thing, as you are aware if you've attended the first session, that IBC override all other laws. So here, even if there is a charge against the company's assets by or there's a lien or anything, that all those things come for a halt here. So that is very important aspect In fact, any practicing IP knows the value of this section or understanding of this section. It really helps the process to go more smoothly if this section wasn't introduced. Trust me, the operational issues that the RPs would face would be way higher. So this section makes the life of a resolution professional very easy. In fact, it helps the bankers or financial institutions to arrive at any conclusion in much smoother manner. So just like section 14 of CIRP, there is a moratorium which is introduced here. Now, that is the pre-initiation phase. On the date of application of the admission of the application, the post-initiation phase happens. Now, the pre-packaged insolvency has been initiated, and the next step is will be taken up in next few slides. Right. The first thing, like I said, the time frame is 120 days. Within 120 days, the process has to be completed. Now, here the basic difference, as I explained, the management and affairs of the corporate debtor shall continue to vest in the board of directors or partners of the corporate debtor, which is a huge, diversion from corporate insolvency resolution process, where the powers of the board vest in the resolution professional, and the management has to provide the support, all right, but they are not in the driving seat. They are not managing the day-to-day affairs. Every payment, every this thing has to be up by the board of directors have to take approval from the resolution professional. So this is a huge shift from the usual CIRP, and this in some ways helps the enterprise retain, because like I explained earlier, for those who have joined late, this helps the management to retain the value of the enterprise, because they know the nitty-gritties and they know the day-to-day operations in much more detail than the resolution professional. And since the period is very small, by the time the resolution professional really takes over the reins of the company, understand the processes, half the CIRP period is over. So this helps them to keep the concern going, and the operations run in much smoother manner. So after commencement, of course, the first thing that the resolution professional has to do is within 2 days, they have to make an advertisement. Of course, that will be in the next slide, but they have to make an advertisement in the newspaper, one English and one local daily, for that the process has been initiated of the pre-packaged insolvency resolution, the process that it has been commenced against so and so corporate debtor. There has to be advertisement in the newspaper, and along with that, they have to obtain a list of claims of the respective creditors, what their security interests are, if there is any guarantee provided by the corporate debtors. All these details they have to obtain. And one more thing, the management has to submit to the resolution professional all these details along with a preliminary information memorandum. Again, I'll take a 1 minute break here to explain the difference between PIM and the information memorandum. Basically, when we propose a resolution, in normal CIRP, the resolution professionals, when I say the word we, because I'm a resolution professional in few cases, so what we have to do is we have to compile the information about the corporate debtor. Of course, there's a basic information given in the law itself as to the basic information that you have to provide. But as per the judgment of the resolution professional, the information memorandum basically contains all the details of the corporate debtors, of the assets, of the liabilities, of the claims, of any pending cases, of transactions with related parties, balances, receivables, everything. The information memorandum is the Bible, which helps the prospective resolution applicant make a decision, whether prima facie decision, of course, once you see the asset and everything that makes, but a prima facie decision about whether they want to participate in the resolution process as buyers, as resolution applicants, we may say. So information memorandum is a document which contains a detailed information of the corporate debtor. The basic contents are provided in the law, but as a resolution professional, and it is based, and there are times when there is barely any information provided, there is a non-cooperation by the management, there is barely any information available. So the information memorandum, the details can be obtained from various sources, from ROC sites, or from the documents of the corporate debtor, or from the emails, etc., of the corporate debtor, or from the server, and they have to compile an information memorandum which contains details of all the relevant details for any prospective resolution applicant. Here, in prepackaged insolvency resolution, that information, the preliminary information, is provided by the management itself. So that is known as the PIM, or the preliminary information memorandum. So that's there. So after commencement, they have to make an advertisement in the newspapers. They have to make, the management has to provide the list of creditors, security interest of various parties, preliminary information. All these things have to be given by the management to the resolution professional. Okay, moving on. Okay, public announcement, like I said, the public announcement has to be made. So these two slides we have covered, and I'm moving forward. Now, approval of a base resolution plan was already provided by the corporate debtor to the financial creditors. And that's where the whole process started. But it doesn't end there. Again, I'll stop it here. I'll go back. Law says if there is no operational creditors are being paid in full, and there's no impairment to this, right, the resolution plan can be passed. But if they're not being paid in full, then the financial creditor may say that, okay, you bring in some other investor and again apply, you give me a better plan. Or even otherwise, even outsiders, there is no, it is not mandatory upon the, now the committee of trade, one important aspect, sorry, I'll break there. Once the resolution professional is appointed, within 7 days, based on the information provided by the management, the resolution professional, and based on the claims obtained by the financial creditors, the resolution professional has to form a COC, and within 7 days they have to convene the first COC meeting. Now it is not, even though the whole process of PPIRP started with a base resolution plan, it is not mandatory upon the financial creditor that they have to take that plan only. If they feel that this plan can be bettered, they can ask the corporate debtor themselves to improvise the plan, to improve upon the plan, or even they can ask for prospective resolution applicants, someone outside the, outside resolution also can be accepted. So if they can be advertised saying, okay, this is the plan we've received, but we want something better. So through Swiss challenge method, there can be an open bidding, in fact, and if there is a better plan, the financial creditors with 66% of voting can go for that plan as well. So like I said, the base resolution plan is only a starting point. But if there's a better plan, the financial creditor can approve that plan and go in for somebody else, not just the corporate debtor. So it is not mandatory upon them to accept the plan given by the corporate debtor. They can always go for better plan. Are we okay? Is the speed okay? I'll stop here. Yes, sir. Sir, ma'am, are we okay? Can I go forward?
Yeah, we are okay, Kartik.
Great, great. Every feedback helps, sir. Thank you.
Thank you. Yeah, definitely.
Right. So moving on, like I said, there is a base BRP. Every time I say the word BRP, that means a base resolution plan as provided by the corporate debtor. They may approve it. The financial creditor may say, okay, the operational creditors are being paid. We have already approved the plan. We can, and they can submit the plan to adjudicating authority for final approval. But they may go for a better plan, they may ask for a better plan from the corporate debtor or from outsiders as well. So that is something that, so there is a base resolution plan, but there can be a best, the COC always wants to go for best alternative plan. So they may, if they feel that this corporate data, the operational creditors are not being paid in full, the committee of creditors can always go for a better plan, which is called the best alternative plan. That means apart from this plan, if there is a better plan, that also can be approved, and that shall be called as the best alternative plan. So through Swiss challenge method, in fact, they can be, it's no rule that it can be done only once. Till the resolution period is there, they can keep on asking for better plans than that. So there's no limitation that only once a plan can be approved and no other plan can be accepted. They can keep on enhancing the value, or the applicants, and they can go through Swiss challenge method. Basically, they can go for a better plan. So basically, with by interacting with the resolution professional, having a correspondence with them, they can always go for a better plan. Are we clear on this? This is a very, very important aspect, because a lot of people believe that once the corporate data goes into pre-packaged insolvency, now the whole thing is done. Nobody else can take over the company. That's not true. There's always a scope for and best alternative plan here. Okay, so if there is no other plan, the corporate debtor has provided with the base resolution plan, which can be approved. Or if there is a significantly better plan, then the financial creditors shall go for best alternative plan. So we are clear on this, so I'll move forward. So basically, if there is no plan approval, if nothing happens, the the financial creditors are not happy with any of the plans, there can be a closure of pre-packaged insolvency resolution process. And this is where, like I explained earlier, the basic differences. CIRP always ends either in resolution or in liquidation. It can, if there is not a withdrawal, they cannot go back to where they began. But that's the difference here. Here, the prepackaged insolvency can be terminated and life can go on as usual. You can again go for banks with better plan or OTS system, and life will go on as usual. So when does prepack? And one more thing, at any point of time, the financial creditors having more than 66% voting right can go and convert prepackaged insolvency resolution process into corporate insolvency resolution process. If they're not happy, like I said, they can even under PIRP, they can take over the management of the company from the management and give it to the resolution professional. They can even convert a prepackaged insolvency resolution process into a regular corporate insolvency resolution process. So if there is no resolution plan passed, the base resolution plan has not been approved, or 66% of the financial creditors, unrelated financial creditors, want to withdraw from prepackaged also, they can withdraw even after they've approved, but they want to withdraw. That also can happen. Through this, there is a closure of prepackaged insolvency resolution process. So now we know. So that was it. That was the basic of prepackaged insolvency resolution process. So I will run you through. I'll take your queries and then we'll move to. There are still certain aspects which I would want to explain, which we will go through. The frequently asked questions, when I go through that, you will have much better idea. So any queries for me here? Anything that you would want to ask? That's basically pre-pack. Once you understand CIRP, pre-package is just one small bit of CIRP, but it has a huge impact, because majority of our clients, in fact, one thing I would want to insist here, that the Reserve Bank of India has given a directive to the bank that if a person comes with an OTS proposal, if it's a company, if it's an LLP, you encourage them for prepackaged insolvency rather than OTS, because once the process go through NCLT, um, it's more sacrosanct and it's much more, the hassles will be much in later in life about approvals, who approved it, how did they arrive about this amount and all. So, and since there is an NCLT approval also, it's far more authentic than any other resolution process. Yes, I could hear some query there, so I'm stopping here. I'm taking your query, sir. Hello? No queries? Should I run through the FAQs here?
Yeah, Neeraja ji, I understand we can go ahead with.
Okay,
if you-
perfect. Thank you. Okay. So both the slides, the FAQs and okay.
And Neeraja ji, 1 minute. If
Yes, sir.
anyone has any query, he can definitely ask in between. No issues about that.
No,
Neeraja ji?
absolutely no. Absolutely. In fact, I like it that way. I prefer it that way because it gives me assurance that my audience are not sleeping.
No, they're not sleeping. Definitely. If anyone has any query, he or she can ask on the.
Yeah. Like I said, I've not bored them to sleep. That's always an assurance to
No,
any
definitely.
speaker, especially on Zoom, because we can't see them. If there's somebody snoozing when there's a live session, then we always know. But here, I wouldn't know that. So any feedback is good for me. Right. Okay. Now I will run it through. I have prepared frequently asked questions for this. It answers the question in a very, very small manner, and it's very easy to understand this way. The first thing is, who can apply? So companies or LLPs which are micro, small or medium scale enterprises as per the MSME Act. Currently, the definition is that the investment in plant and machinery should be less than 50 crores. I'm sure all of you are aware of that. So that's the basic criteria there. Earlier it was different for service and goods, but now the whole criteria has come down to one. In fact, I have even applied. One of my clients was a hospital. So we have obtained an MSME Udyam certificate from them. The company was in CIRP and the person did not have an Udyam. My corporate data did not have this thing. We intervened. I was the advisor there. So we got an MSME certificate from them in between the process, and we made them eligible to bid for this. Of course, that was a CIRP procedure. But then if you're an MSME, eligible MSME, who is eligible MSME? Those who are not disqualified to give a resolution plan under section 29A of IBC. I'm sure that would have been taken up in much detail during the previous session. Anyways, to section 29A, since I have been talking about it, I'll again give a note on that who are eligible under section 29A of IBC. Now, what is the minimum and maximum amount of default? Minimum amount is mentioned here, 10 lakhs. But no maximum amount is specified. In fact, maximum amount is not specified because it anyway gets disbarred. If you're not an MSME, if you're a large enterprise, there's no need for a maximum amount here. So there's no maximum amount. Okay. One query which a lot of people ask me is, only can the default be of to the banks or financial creditors? No, the default can be to an operational creditor if you're not been able to give the money against goods or services that you have obtained. That also comes under the definition of default. Even against a default to an OC, operational creditor, you can file, a corporate debtor can file for a pre-packaged insolvency resolution. Which is the relevant section of the law? I'm sure this will make your life very easy, as if you don't want to run through the entire IBC, you can take note. Section 54C of IBC 2006 takes care of the application part of pre-packaged insolvency resolution process. So I have made this into very, very small sentences. Any detailed explanation, though we have had a detailed explanation for 1 hour, I'll be glad to provide. And even after this session, I shall share my number. I will be happy to answer any queries later on also if you want any, if you have any queries on this, of course. Where can the application be filed? Where the registered office of the corporate debtor is NCLT bench, where the jurisdiction where with the registered office of the corporate. The branch office doesn't matter, any other office. What matters is the registered office. Can the application be filed online? Yes, the application can be filed online. But if you feel the documents are too voluminous, the proof or evidence is too voluminous, you can even submit in a pen drive. Or these are basically, now I'm answering, if you actually get to filing, these things will help you a lot about the process of filing the application. Okay. Can the section be filed online? Yes. Who can make an application? This we have taken up in detail. That's any person who has not gone through CIRP or PPIRP or liquidation, or is not undergoing any this thing in last 3 years, or is not going through any liquidation process, is eligible to make an application. So any pre-packaged insolvency can be filed only once in 3 years. If you have undergone that, you cannot. Of course, currently that won't matter because the law only came, the ordinance only came last this thing. It was, so it's not relevant at this point of time. But eventually this point will be very, very relevant, that every 6 months you cannot restructure your loans. Okay. So once the application is filed, now this is a very, very important section, very, very important point. I'll stop the screen share. I'll explain you bits so that you don't read and don't get distracted here. I want you to listen to me, and then of course I'll share the screen. A lot of times my clients come to me and they say, okay, we want to file for pre-packaged insolvency resolution, but there's already an application pending against, the bank has already filed for a CIRP against me, or some operational creditor under section 9 has already filed a case against me. Now how do I file a pre-packaged insolvency? So law is very clear. If both the applications are filed simultaneously, pre-packaged insolvency will be given. If our operational creditor has filed and the corporate debtor has filed for pre-packaged insolvency, pre-packaged shall first be dealt with. First, this will be disposed of or not. Only then section 7, section 9 or section 10 cases under CIRP will be addressed. But if there is already a pending case, then which one will be dealt with first? Law says that if then application for prepackaged insolvency is filed within 14 days, within 2 weeks, 14 days of filing of section 7, 9 or 10 application, then also prepackaged insolvency will be first dealt with. First, this will be disposed of, admitted or disposed of. Only then the other other application will be heard. But if there is a section 7 or section 9 or section 10 as in CIRP applications of pending against corporate debtor, and after 14 days if you have filed for prepackaged insolvency, then first section 7 or section 9 shall be heard, or section 10 shall be heard. Section 10, it won't be very relevant because if you are filing for both, you'll withdraw that first and make this application. So I will not insist so much because law says section 7, 9 and 10. But at the end of the day, 10 is filed under section 10, application is filed by the corporate debtor. Pre-package is also being filed by the corporate debtor. So obviously, they will withdraw that first and make this application later. So that is not too relevant. The law does contain it. Section 7 and 9, if they're already pending and pre-packaged insolvency application is filed later than that, then first CIRP application will be heard. And if they are being disposed of, only then prepackaged, there's a scope for prepackaged. Otherwise, the company will go into CIRP, corporate insolvency resolution. So that's the order. I can read it for you here. It's a very, very important aspect as such, because A lot of clients against whom there's a case pending, there's an application filed, they come up to me and say, ma'am, we want to go for prepackaged insolvency so that we can beat the corporate insolvency resolution process. We can keep the management under my control. That's not an option. Here, if you can see point C, it's very, very clear where an application under section 54C is filed. 54C, that is prepackaged insolvency resolution, is filed after 14 days of filing of any application of under section 7 or 9. 10 also is given by the law, but it's not too relevant because it's by you, you can always withdraw it. In respect of the same corporate debtor, the adjudicating authority shall first dispose of application under section 7, 9 or 10. So this is something that you have to guide the client. If there's already an application pending, sir, sir or ma'am, you cannot go for prepackaged insolvency resolution. That's a very, very important aspect. In fact, the maximum number of queries from my clients that I get are over this point. So I hope this is clear, because when we advise the client, we need to be informed about these things. Otherwise, it will be total misguided. We will file pre-IIP, and if tomorrow the court, takes cognizance of that, and it's a very, basic information that every professional should have. So this is something that you need to make a note of. So if you have to ask me, as for advising the client, what is the basic requirement that we need to understand, ma'am, before we suggest PIP to my client? First thing, MSME. Second, eligibility under section 29A. Without looking at that, we cannot go to the client at all. We cannot advise the client. Third, if there is an application pending against the corporate debtor, same corporate debtor, then we have to see when that was filed, and if it's been more than 14 days, then maybe you can always file, but you have to tell the client that that will be first disposed of, and if that goes, if that is in your favor, only then this will work. So that has to be advised to the client very well. And the third amount, please, I know I'm insisting upon this matter a lot. CIRP, the amounts is minimum default is 1 crore, but here the minimum default is only 10 lakhs. So please don't get confused between the two. And if I'm repeating too many times, I would take your excuse there, because there are certain things which as professionals we need to be very, very clear about. Okay, this process we have gone through. The process before filing, internally, before filing the application. Again, first thing is a declaration that once the base resolution plan is approved, within 90 days an application can be made. You have to tell the client, once the 90 days are over, once it is passed by the financial creditor, you have to file within 90 days. You cannot scout for funding. Where will I get the money from? कहाँ से आएगा पैसा? अभी सर मेरे पास तो पैसे नहीं थे, मैंने तो ऐसे ही इनिशिएट कर दिया. भाई, you have to make to the client very clear कि एक बार आपने डिसाइड कर लिया है तो आपको 90 दिनों के अंदर अंदर ये एप्लीकेशन फाइल करना पड़ेगा. Okay. Second, name of resolution professional proposed. A written consent has to be obtained. You cannot just name. You cannot choose your resolution professional. You have to obtain a consent as well from the resolution professional. And third, and very, very important aspect, a special resolution has to be passed by the members of the company or partners of the LLP for filing of prepackaged insolvency resolutions. This is the internal aspects that you have to take care. Prerequisite percentage of approval from financial creditors for filing. I think we have mentioned it many, many times. It's 66% in value, not 66% of numbers. 66% of value. How it is calculated? Total debt and individual percentages are calculated. And in fact, I would want to make it clear here. In CIRP, the amounts are calculated of the due amount. A lot of times the bank stop. We like to believe that NPA has been, that has been declared an NPA in 2018. After that, there's no interest calculation. In CIRP, when banks or corporate debtors, operational creditors make a claim, they can take interest calculation penalties which they believe are right up to the date of filing of the application. So that is something that you have to take care. That when you see the claim, as per the claim approved, the 66% in value of financial debt, unrelated financial parties, those who are related parties, they're not considered. Their approval is not enough. So related party has been defined in IBC and very, in detail. So if you're going for that, of course, every person, while calculating, every professional will have to look. First thing that you have to look at is Section 29A and definition of related parties. These are two things that before advising it. Now I'm telling you more in terms of advisory to the client, because majority number of people here must not be IPs. I'm believing that they are here because they want to understand the process so that they can put it to use while advising their clients. Sir and ma'am, the first thing that you have to look at is Section 29A of IBC, and secondly, that 66% in value of unrelated financial creditors have agreed for prepackaged insolvency resolution. Now, what is the duty of the insolvency resolution professional? That is for us. In Form A, they have to make a basic report has to be made as to why, what happened, what about the corporate debtor, what is the business, line of business, why they went into, why the default has happened, or if it's an NPA, why the NPA has happened, what are the advantages and disadvantage of this process that will have for the client. Basically, a report has to be made by the resolution professional. So the first step, this was approval of financial creditors, Section 10 and everything was to be done by corporate debtors. Section 9, question number 9 was for the corporate debtor internally. Now, question number 11, this is the duties of the insolvency resolution professional, right? The RP appointed. So they have to make the report. They have to file the report with the board before filing of the application with the board, and then before filing the application with the adjudicating authority, they have to make a detailed report about the corporate debtor. Okay. Relevant forms. See, form number 1, I can say that it is the relevant form, all right. But forms and this thing, it's a very, very small it's a very small part that not many forms, you can always look at them. That's very easy part to understand. So I'll not go too much into details about the forms. Now, this is a very, very important operational aspects. The documents that have to be filed along with the application. First thing, in case of financial debt, a record from information utility. Okay. So this is a very important aspect. For financial creditors, it is mandatory now to have their debt recorded with the information utility service providers. So you have to obtain, if in case of financial debt, if the default is a financial debt, you have to obtain this thing from the information utility. This is something that every professional has to make note of. In case of operational data, you have to see how did the debt happen, the copy of invoice, demand notice served upon that you have, they have served upon your demand notice which you couldn't pay, or any details, documents supporting a fact that a default has happened. See, it is not that they are asking, the inability that you have not been able to pay. They have asked, but we have not been able to pay. See, there's a difference here. I'll again take a break here. When we file CIRP, under Section 9, the application is being filed by the operational creditor. They have to first give a demand notice, and then they have to prove it to the court that we demanded, 10 days are over and they did not pay payment. Here, the same demand notice, if there is a debt, just the fact that there is a debt is not enough. There's a default in payment. The operational creditors has served upon me a demand notice and they've not been able to pay. So this is something that you have to, this proof has to be given along with the application. Declaration special resolution by the members of the company, declaration that they're eligible under the code for under section 29. This thing has to be given. Written consent from the resolution professional. Okay. Directors have to give a declaration that the eligibility is there. All these things have to be provided along with the approval from the creditors that a base resolution plan. 66% of the unrelated financial creditors have agreed for it. This has to be planned. So these are report, as mentioned previously. I had mentioned that under duties of financial resolution professional, a detailed report. Along with that, the past 2 years financial statements also have to be given. Now, point number I is very important. When there is a CIRP, a resolution professional forms an opinion about preferential transactions, okay, or any avoidance transactions, as we call it. If there is a fraudulent transaction, if there is extortionate credit transaction, or if there is a preferential transaction to any related parties, the RP makes an opinion. Here, the resolution professional, even before filing form, looks through the transaction. It is not the duty of the resolution professional just to file. They have to form an opinion. If there has been any fraudulent activity, if there has been any, a preferential transaction which has happened to the related, if any preferential payment has been made to any related party. So it's a very, very detailed topic in itself, preferential transaction. If it has happened, they have to make a declaration that such transaction, what is his opinion on that thing. He has to file a report on that as well. He or she, the resolution professional, has to file. Affidavit by the board of directors, books of accounts, copy of financial statements, statement of affairs before 14 days of application. We've discussed these things. These are the various documents that have to be filed along with the application. Next, date of commencement of PRP. Of course, the date of admission, commencement of CIRP by the adjudicating authority, NCLT, when it admits the application for pre-packaged insolvency, that is the date of commencement. Timelines for completion, 120 days. You may get confused, 90 days and 20 days, 120 days. 90 days is for filing the application. From the time financial creditors has approved, filing of application has to be done within 90 days. After that, within 14 days, the adjudicating authority has to admit it. Once the admission happens, from there, the process has to take 120 days. So this is the timeline for completion of prepackaged insolvency. Who manages the corporate data? As we have already discussed, the biggest advantages of this section is that the management remains with the corporate management of the corporate data, except where they believe. Of course, there'll be controls will be placed by the resolution professional. The resolution professional cannot hand over the management to the corporate debtors management directors and say, okay, मैं आता हूँ, मैं आपसे 120 दिनों बाद मिलूंगा. ऐसा नहीं होता सर. During the process, पूरे controls उनको exercise करने पड़ते हैं, monitoring करना पड़ता है कि कहीं ऐसा, क्योंकि इस समय moratorium भी है, moratorium has been imposed. तो ऐसा नहीं है कि they are taking undue advantage, they are selling off assets of the company. That cannot happen. There have to be proper controls and checks by the resolution professional placed on the management. And at any point of time, if the financial creditor with 66% voting right believe that the company is not being managed by the management properly, they can shift the controls, or the powers can be shifted or given to the resolution professional. When is the COC formed? For the beginners, COC means the committee of creditors. Committee of creditors comprises of financial creditors. And voting rights are only with unrelated financial creditors. COC contains related and unrelated parties both, but voting rights are only with unrelated financial creditors. Within 7 days of commencement of pre-packaged insolvency resolution, COC has to be formed. When we form a COC, we have to file it with the adjudicating authority. The composition has to be filed with the adjudicating authority. Members, their amount, the voting percentage of various this thing, that is the composition of CIRP, which is to be filed with the adjudicating authority by the resolution professional. Can the management of corporate data vest with the resolution process? So I'll take a break here. Hello? Was I sharing screen till now?
Now
Was
you
I?
have started sharing.
You could.
No, now
suddenly
you
I-
have started sharing.
Pardon, sir?
Now you have started sharing the screen.
Oh, sir, somebody should have interrupted. I'm sorry.
No, no, it's okay. It's okay. Your deliberation was so detailed.
Okay. Thank you, sir.
Yeah, please.
Sorry, I
Thanks.
was of the opinion that my screen is being shared. Right. So resolution profit. The 18th question. Now my attendees can answer themselves. Can the management of the corporate data vest with the resolution professional? Yes, if 66% of financial creditors, unrelated financial creditor, feel the need of it. Okay. Within 2 days, the resolution prepackaged insolvency day, this thing, the resolution plan has to be submitted to the COC and has to be approved by the COC within 90 days. But like I said, that is not mandatory that they have to approve. It has to be submitted. The resolution plan has to be submitted, but COC can invite. That is the next query here. The COC can invite for more resolution plan. The one given by corporate debtor is not the ultimate one. No corporate debtor can feel that okay, now I'm secured, moratorium is also been imposed, अब मेरा company मेरे से कोई छीन नहीं सकता, ऐसा नहीं है. If the financial creditors and the resolution professional feel that the plans can be better, they can always invite for better resolution plan, best alternative plan as we call it. What happens if the COC does not approve any resolution plan? The prepackaged insolvency is terminated, that's all. It doesn't go into CIRP. It doesn't go into liquidation. That is a huge difference between CIRP and prepackaged insolvency, PPIRP or PIRP as we call it. Can COC initiate CIRP during PRP? Any point of time. If the COC is not too happy with the management, their resolution plan, they can always shift to corporate insolvency resolution process, but with at least 66% of voting by the financial creditors. Now, as I earlier discussed, these are various forms that have to be filed. I will be sharing this PPT, both the PPTs with my attendees. So I believe you can now advise the client, or you can file the case with this information. These are various forms that have to be filed. So that's about it. Thank you. I'm here. So that was all about prepackaged insolvency resolution process. Any queries, sir?
Dear delegates, if any queries are there, you are welcome.
Sir, you have to ask questions because our session has ended in 1.5 hours. Your CP hours also might be reduced if you don't ask any queries.
Neeraja,
Yes,
ji, I think this one particular, this is only one part of the whole CIRP.
This is a very small
And
part
so
of the CIRP process. It's only one
Yes.
section. It's only one section. So that way you can understand that if we take CIRP for 2 hours, we definitely don't need for 2 hours for prepackaged insolvency. But unless, but the fact is, if we understand the CIRP also along with this, then it might, even 2 hours are not enough. Yes, sir. So I have a query here. What parameters will adjudicating authority consider before? If 100% OC and other statute dues are written, no. 100% in base resolution plan, 100% OCs have to be paid in full in the base resolution plan, right? So that is not an option. They can always call the base resolution plan OC. That's a basic deviation for all those people who feel that if there is a deduction in OC amount, then base resolution plan will not be approved. They will have to go for better resolution plans. Does that answer your question, sir? Base resolution plan you cannot write off. This is the biggest variation from CIRP. In fact, that would be the reason why a lot of MSMEs would prefer CIRP over prepackaged insolvency resolution.
Ma'am, and what about the statutory dues? Will they be written off?
Those are operational creditors as well.
Those are also OCs. Okay. Thank you.
There is an option, yes. You can, there can be deduction, but that has to be, then they will ask you to get another applicant with you, along with you, or they can go for a better resolution plan. So 100% writing off is not an option. Yes, sir. Then there is no PIRP, then it goes back to life as usual. Right, sir. Does that answer your question? Hello? Yes, sir. So here in CIRP, the law says, if I'm sure you've attended CIRP session, or if you do not, CIRP says that basically if the company goes into liquidation, whatever value they would get, the operational creditor or unsecured creditor, whatever value they would get in the liquidation process, minimum has to be given here. So that's the law with CIRP. So everywhere complete writing off is usually not considered a this thing. Here you cannot write off the operational creditors 100%. NCLT would not approve of it. In fact, base resolution plan cannot be approved like that. Right, sir? Anyone else?
Any questions, dear delegates?
Any topic that you would want me to take in detail? I have good 20 minutes, so I can always take any more. Section 29A, should I take that up? Because that is again a very, very important aspect for those who have not attended CIRP. Section 29A under IBC is the most important aspect as to.
Yeah, Neeraja, even if somebody has attended, it is definitely better to listen to two voices.
Right. So let me just. Okay.
Neeraja, I understand
Again,
there
I'll
is one
start screen sharing here. Yes, sir. You're saying something.
Neeraja, there is one question. I understand there is one question in chat box. You can look at it.
Yes, I can see a very good question here. That if there is a prepackaged insolvency resolution process, the default amounts are very, very different here. The default amount in prepackaged is 10 lakh rupees and the in CIRP is 1 crore rupees. Law is silent on that aspect. Law has not mentioned anything about that aspect. Okay. So we shall have to take it as there has to be more clarification on that, or there has to be a case law on that. It just said that it can be shifted to CIRP, but yeah, eligibility has, my take on it would be the eligibility has to be minimum default will have to be, then has to be 1 crore rupees. If it has to be shifted to, otherwise every person will take this route where they can enter through PIP and shift into CIRP. So no. So that would be, my take on it would be, it should be at least 1 crore minimum default value to be shifted to CIRP. So that was a very, very interesting question. The law is silent on that aspect for now. Yes. So I'm taking section 29A, eligibility under section 29A, very, because for MSME to be eligible, all MSMEs are not eligible. For MSME to be eligible, section 29 is a very important thing. They have to be eligible to present a resolution plan, section 29A of IBC. So the person has to be an undischarged insolvent. If they are, not be eligible, of course, it's a negative this thing. If is a willful defaulter, then of course they're not eligible under section 29A. If they have been, they are willful defaulter declared by the bank or by the RBI under the guidance of RBI, then they are not eligible to present a resolution plan, and so they are not even eligible for pre-packaged insolvency resolution process. Okay. Now, point C, at the time of submission of resolution plan on account of corporate debtor, this basically says, and again for CIRP also, this section, if it's an MSME, this section is not applicable. This section under section 29A, under section 240A, there's an exemption to this, that if a person, if the management, or if there is a management, if there is an individual who is managing the company, and if some other company has gone into insolvency, then they cannot be eligible here. So this thing has been done away with for MSMEs under section 240A. So this is something which is not relevant for this point of time. So I'll read it. At the time of the submission of resolution plan, on account of corporate debt, account of corporate data under management or control of such person, of whom such promoter classified as NPA with the guidelines of RBI, or under financial regulated issue or under any other law for timing in force for at least a period of 1 year has lapsed on the date of such classification. So basically, if somebody has been declared NPA, they were earlier not eligible. But if you want the same MSME to apply for resolution, then obviously their account is NPA. So this section is not applicable for MSMEs. This is not under section 240, this is not applicable for MSMEs under IBC. Because I am applying for pre-packaged insolvency because I am an NPA. So if this point is taken under consideration, then they will never be eligible. So this is done away with. This is exempted under section 240A. Now, basically, explanation, these are for financial related parties. Definition is not the same for financial regulators and others. So that is an explanation given here, that the person, if their related party is also ineligible, then they cannot apply for this. But this section is, like I said, is not applicable here. Point number C. Point number D says, if they have been convicted of any offense punishable for imprisonment for 2 years or under 12th schedule, or 7 years or more for any timing in force, for any financial frauds, if they've considered and they've been convicted, then they're not eligible. This point is still applicable. It is not exempted even for NPAs. So willful defaulters or those who have committed financial frauds are not eligible under section 29A. If you're not ineligible, sections, point number C only talks about if you're an NPA. But the whole point is MSMEs are exempt from this point. Only then they can go for PRP. So this point is not relevant, but point number D is very, very relevant. So you have to ensure that the person, your corporate debtor, has not been declared as willful defaulter, has not, any of the management personnel have not been imprisoned for financial frauds or otherwise, or under 12th schedule for more than 2 years. These things have to be considered before filing an application. Now this point number E, is very, very important, and it is not exempt also for even MSMEs. Lot of times, in fact, my clients have come for me for advisory. What happens is, if their DIN number is cancelled in some other company, not in this company, some other company also, they are not eligible under section 29A. So any person who are disqualified to act as directors, if they are managing per year, if they're applying for this pre-packaged insolvency year, they're not eligible. So this is something that you have to take care. Now, if you have committed any securities fraud, you're again, you're not eligible. If the promoter or the person, management personnel are involved in any preferential transaction, not just an application has been filed, if they've been adjudicated upon, if they have been a part of any preferential or avoidance transaction, if they have committed anything as adjudicated by the authority, then the person is not eligible for prepackaged insolvency. And point number H again, which is exempt. What happens is, why I'll explain why this is. If a person has executed a guarantee in favor of the corporate debtor, which is an insolvency. Now, if I am myself applying for company, of course, I've taken a loan and 90% of the time they have executed a guarantee. So the NPA point, if you're an NPA, otherwise you cannot apply for some other company. For MSMEs, this point is exempt. To point number C and H of section 29A are exempted for MSMEs. That's the reason, even if they are guarantors for the same loan which they have defaulted, they can still apply for prepackaged insolvency. Okay. So not just in this country, under these points, if you're ineligible outside the jurisdiction of India, even then you're ineligible. So not only in India, if you're ineligible under section 29A outside India, you still will be considered as ineligible here. Or you have any connected person, your company or any other person, associate company, holding company, subsidiary company, if they are also ineligible under section 29A, then you're also ineligible. So section 29A in itself is a very huge topic. So I've taken up the very basics of it. What I can say is, when you take up section 29A, the prima facie factors that you have to consider is that they're not willful defaulters, they've not been declared as fraud accounts, or the directors' DIN numbers are not cancelled. So, or these are the basic points you have to keep in mind. So that's about it about section 29A. Like I said, it's a due diligence. Section 29A in itself is a huge topic which can take at least 45 minutes if we go in detail. But for our purpose, this bit is good enough for taking it forward. So do we have any more questions here? So we still have 15 minutes to go. So it's 6:45 by my time. So till 7 is my session. In any I've drawn parallels with CIRP and PPIRP, but I've not gone too much of details in CIRP here. If you have any queries about CIRP, which you feel you're not able to connect, I shall be glad to take up the question. Yes, sir. Okay, at least an assurance that people are not snoozing will be good.
Yeah, Neeraja, they are there.
Yes, sir.
Yeah.
बोलिए सर. दिनेश, आपके भी कोई queries है तो पूछ सकते हैं. I'm typing my number here.
Yeah, definitely. Please. If you can type your number and also your
I'm
email
adding the PPTs. I'm adding right here, of course.
Okay.
1 minute. I'm just trying to figure out how. Just a moment. I'm just trying to figure out how to do that. Can everybody see my number? Has it come?
Neeraja, or we can share it with everyone, all the delegates from the branch.
I'm just trying to. Okay, I'll just, yes. Everyone in meeting, yes. Sorry. That's my number. You can call me for any queries on CIRP, on liquidation, not just PIRP. Of course, this session was assigned to me, but I'm a resolution professional. I'm a liquidator in a few companies. I can, of course, guide you on all matters. Or if you want to invite me for tea also, you can call me. I'll be more than glad to accept the. Yes, that's the thing.
Yes, Neeraja ji.
Yes, sir. Boliye, sir.
You have shared the PPT, or we can share it with from the branch also.
मैंने अभी शेयर किया है सर.
Okay. Any more queries? Any more questions from the delegates?
So I've shared the documents. Okay. So I believe we had a good session here and not too many queries. So I thank you all for your patient hearing, and I'm hoping that this session will help you in your profession, in advising your clients, because definitely I mean, though I'm not too much into audit and a full-time IP, but I know the amount of defaults which are happening, the amount of NPAs that are there in the market, and you can definitely advise your client with PIRP. There are a lot of advantages over OTS, over these things here in prepackaged insolvency resolution, or for that matter, even CIRP, if done right. If it's an MSME, even in CIRP, they can apply for their own company, they can bid for their own company, they're eligible under Section 29A, of course. So that way, understanding of basics, or not everybody has to be an IP or has to know in depth of everything. But I believe that basic understanding is very necessary for advising our clients the right way. In fact, like I said, the RBI is giving directives to the bank to go for prepackaged insolvency if eligible rather than OTS also. So understanding of these things I'm sure will definitely help you. For any queries, you all have my number now. I'm very much, I'm from Nagpur, 3 days. We have an office in Mumbai. So most of days, and my projects, a lot of projects are in Mumbai. So I'm a lot of times I'm in Mumbai, and I'm mostly in Nagpur as well. So any person who wants to meet me in person or have any sort of queries, you can always call me, WhatsApp me. It'll be my honor to answer your questions. In fact, question from Rishi was very interesting because I did think about it, but I never. We have yet to come with a case law on that, so we'll have to wait and watch. So there are many things which we learn through interactions. So it was a great session. I want to thank Jiten ji and Dinesh ji and all the team members for giving me this opportunity. Thank you very much.
Thank you, Neeraja ji. And it was definitely a wonderful session for all of us and all the delegates. And I understand all the delegates will definitely get benefited from your deliberation on this. And I recognize the presence of our past chairman, Anil Parekh sir and Sudhir Surana sir also. And
Hello,
thanks Neeraja and all the delegates.
Honor, my pleasure. Namaskar, sir. Thank you very much.
Thank you, Neeraja. Thanks a lot.